I'm here on my son who's passed away behalf and my other 3 children who have been taken away from me due to fraud. I have found every bit of proof that I need to prove my innocence and to get justice.
No court and no party should fear newly discovered evidence, because if the facts are real, they need to be heard. The only people that are afraid of facts are the ones who try to hide them, and that has to be changed. My name is Nick Martino, and I'm a professor of law and an attorney in Florida. Dealing with the application of the statute in Ms. Furman's case, without going into the facts of it specifically, the statute was actually passed after the initial termination of parental rights of her child. So what ended up occurring was the judge was bound by a statute that she could not even have been aware of when she first got pregnant. In a criminal proceeding, that would be absolutely prohibited. They call it an ex post facto law. In a civil proceeding, ex post facto ideas still apply to a certain extent, but in dependency proceedings and termination of parental rights, it was simply rejected in this case. And it's simply rejected in every case dealing with dependency issues. That's another example of a law that is more concerned with simply getting something done than getting something right. And that can't be the purpose of our dependency laws. The purpose of our dependency laws should be first and foremost to get it right. And in this instance, the application of that law after the fact, maybe different decisions would have been made, maybe different family choices would have been made, but we can't know because she could not have known at the time she got pregnant and decided to bring this child to term. One of the unfortunate parts about the termination of parental rights proceeding is that regardless of what sort of evidence surfaces after the hearing, that hearing can never be reopened for consideration by the judge. And it happens oftentimes. So if a proceeding takes place, as an example, and the state is able to terminate parental rights, they call in witnesses, and then after that hearing, new evidence is discovered that shows that the state was incorrect, that they falsified information, or that they simply abused their authority or power. A judge cannot consider that new evidence in order to reevaluate a termination of parental rights. Taking that authority away from a judge and taking that authority away from the person in the room who is supposed to be a neutral arbiter, which is the judge, is simply wrong, and it's not good for the parents or the child.